All right, Supreme Court of Guam session, the Honorable Chief Justice Robert J. Flores presiding.
Afade, good morning. You may be seated. Will the clerk please call the case?
This is Supreme Court case number CRA24-001, People of Guam Plaintiff Appellee v. Ray David Flores Jr., Defendant Appellant. Appearing for Plaintiff Appellee is Attorney Nathan M. Tennyson. Appearing for Defendant Appellant is Attorney Levin T. Camacho. Panel members consist of Chief Justice Robert J. Torres, Associate Justice F. Philip Carbolito, and Associate Justice Catherine A. Merriman. Your Honor, Attorney Camacho reserves 3 minutes.
You may proceed, Mr. Camacho.
Chief Justice, and may it please the court. Due process demands more than a caption. The issue that is presented in this case is whether or not a defendant's due process rights and right to fair notice was violated when the trial court sentenced Mr. Flores to 5 years based on a sentencing enhancement that was not included in the superseding indictment that the government proceeded to trial on. I'm going to just give a very brief procedural factual background just so the court is aware or can track just how problematic the facts of this case are. The government initially charged Mr. Flores with kidnapping as a felony, strangulation as a felony, and assault as a misdemeanor. Both felony charges the government alleged and provided notice of commission of a felony while on felony release. The government then presented that case to the grand jury, and the grand jury returned an indictment with identical charges. And again, both felony charges had the notice of the government's intent to seek a sentencing enhancement for the commission of a felony while on felony release. The government then sought and obtained a superseding indictment. And in this case, in this indictment, they alleged kidnapping and provided the notice of its intent to seek the felony on felony release enhancement, but they removed that same notice from the strangulation charge. That is the indictment that the government proceeded to trial on. At trial, the trial court granted the motion for judgment of acquittal with respect for the kidnapping charge. And at that point of the case, after the government had rested, there was only one felony charge that remained, the strangulation charge. And based on the language of the body of the superseding indictment itself, there was no notice of an intent to seek a sentencing enhancement based on the commission of a felony while on felony release. This lack of notice was brought up to the government during the discussion of jury instructions, and specifically with respect to the form of the indictment that would be presented to the jury. Now, the reason why this discussion came up was there were 2 defendants in this case, Mr. Antalan and Mr. Flores, and it was really more of a practical consideration. What would you do? How would you redact all of the charges against a co-defendant as well as the kidnapping charge against Mr. Flores? If they redact the straight redaction and they talked about using white tape, basically you would have several pages of blank documents before you got to the 2 remaining charges against Mr. Flores. During this discussion, the government said, perhaps we'll seek a second superseding indictment. And the court asked, well, how long would that take for you to get it? And they said, we could get it quickly. The government never moved on amending its indictment to reflect any notice. At that point, defense counsel properly objected to the lack of notice provided with respect to the strangulation charge. And the trial court essentially said, well, we'll take it under advisement and we'll proceed to presenting the jury with the jury instructions.
You're not arguing that the government is required to provide notice of the intent to seek a sentencing enhancement in the indictment. All you're suggesting is that you have to be given fair notice of it under the due process clause, and that could be done in the indictment, in a notice, in a separate motion. Is that right?
That's correct, Your Honor. And I will admit that the court's language in Murtaugh, where it said pretty plainly that the court is not going to adopt a rule that all sentencing factors have to be presented to the grand jury based on jurisprudence. And I believe the trial court relied on that in Apprendi in saying, well, then it doesn't have to be in the indictment. We are not arguing that it has to be presented in that indictment. That's settled in Guam. The bar is not high. There just has to be some notice of the government's intent to seek a sentencing enhancement. And as the court pointed out, it has been done.
And you think the caption was insufficient to give that notice? Why?
Yes, Your Honor. I guess I'll start from the caption itself didn't provide any note. It just said notice of commission of a felony while on felony release. And that was it. I believe that the elements that the government would need to establish requires more. I think more importantly for this case, in the body of the indictment itself, they removed it. So the caption said one thing and the body said another. And defense counsel and Mr. Flores, I think, properly relied on the body of the superseding indictment in both developing trial strategy and evaluating whether or not to negotiate a plea agreement. I will point out that under this statute, so Mr. Flores was sentenced to 1 year for assault, 3 years for strangulation, which is the maximum for a first offender, and then 5 years for the sentencing enhancement. So Mr. Flores received more time for the sentencing enhancement, which was not in the body of the superseding indictment, than he did for both underlying offenses. I'd also note that
what would the defendant have done differently in preparation for his defense had the language been included in the strangulation count?
Yes, Your Honor. I think this is, I have to acknowledge that the preparation itself probably would not have been that different. But that's not what.
I was going to say, because already the special allegation was included in the kidnapping charge, and that he was put on notice that there was a special allegation that he had to prepare for prior to trial.
Yes, Your Honor. That was properly noticed for the kidnapping charge. What I would tell the court, and this has been recognized in Anderson as well, that part of it also deals with informing a defendant of what the possible range of penalties will be if you are convicted, which would include the sentencing enhancements. Now, in this discussion between trial counsel and Mr. Flores, you're looking at, so you would have 3 years. I don't know if there's a different statutory, but based on first offender felony, 3 years plus 3 years plus 1 year, a maximum of 7 years if you were convicted and sentenced. With the sentencing enhancements, you're now looking at 5 to 25 consecutive, plus another 5 to 25 consecutive. So you've gone from a potentially 7-year sentence to 57 years. And when you're explaining to a defendant what the offer is from the government, and I think trial counsel was very candid when they got to the second phase of the bifurcated proceeding, that if it had been properly noticed, there would have been a stipulation that Mr. Flores was on felony release as a commissioner.
So your argument, as I understand it in part, is that in analyzing and deciding in terms of advising the defendant whether to proceed to trial or not, if the understanding that the special allegation was not part of the strangulation charge, then if the defendant, in analyzing the potential penalty and how to properly conduct its defense, if it kicked out the kidnapping charge, then all it was facing was the strangulation, which was maximum 3 years. And so in that particular case, whether he decides to plead facing all these the special allegation tied to the kidnapping charge, or rolling the dice and go to trial, beat the kidnapping charge and only being faced with 3 years is what you're saying was what was taken into account in deciding whether to go to trial or not.
That's correct, Your Honor. I believe it definitely changes the analysis. And as a defendant, again, 57 years versus 6 years is quite a different in terms of weighing whether or not you want to proceed to trial. The defense counsel and Mr. Flores may have looked at the kidnapping charge and knew even on the front end that was a weak charge. And we don't have to get into how difficult it is to prevail on a motion for judgment of acquittal, but it was granted in this case. So at that point, And if you look at the case, at the moment that this issue is brought to the prosecution's attention, they still had under 8 GCA section 5520 the ability to amend, and there's great flexibility. And I go back to the bar isn't high. The government had the ability to go and to seek an amendment of the indictment, which is authorized anytime prior to verdict. So at that juncture, the government could have said, Your Honor, hold on. We're going to reconvene. We're going to get a second amended superseding indictment, or however they wanted to term it, and properly notice prior to the jury deliberations. But they chose not to. And this is where trial counsel really was upfront about there's this problem with it. Not a problem. You haven't alleged any notice for the strangulation charge, which is the only remaining felony charge.
And you said this was brought up during the jury instruction phase, the failure to include the facts to support the special allegation of the strangulation.
It was, yes, Your Honor, it was during, I think it was on the.
And not at the later bifurcated trial stage for the first time.
It would not, that's correct, Your Honor. It was brought up, and I was going through and I actually wanted to make a correction as to the page number. I believe it was page 20 of the 18th. It was the date. I don't remember what month. It might have been July. That again, in this discussion of how do you present, and it is an issue. I mean, just thinking through it, how do you present an indictment to the jury? And you start with 12 blank pages. So they were just kind of struggling with how to do that. And that's when defense counsel brought up, there's no notice that follows, that tracks the strangulation charge, and we're going to object.
Mr. Camacho, was there anything in the jury instructions that address this issue in reference to the special allegation not being in the body of the indictment, and trying to enlighten the jury as to how to address this circumstance?
Your Honor, I'm not certain, but I believe that based on the bifurcation, it would have been inappropriate to inform the jury of pending felony charges at the commission, at the alleged commission at that stage of the strangulation and assault charges. But I don't know with certainty. I just know that they had agreed prior to trial based on Apprendi to have a separate proceeding to establish beyond a reasonable doubt that Mr. Flores was on felony release at the commission.
I guess my follow-up question, was there anything that defense counsel could have done in the jury instructions that would address the lack of notice requirement in the indictment?
Your Honor, I don't think, I mean, this really was the government's obligation to fix. So I don't think the defense counsel had any obligation at that point. I think in terms of preserving the issue for appeal, at the earliest opportunity, it was brought to the attention of the prosecution, and they elected to proceed on the superseding indictment that they had started trial with. So it was really two key decisions that the government made. The first was to remove the notice of the sentencing enhancement from the superseding. And the second was to not correct the mistake, if it was a mistake, prior to there being a verdict issued. And the government has rested on basically the caption, which goes back to my opening statement, that the government's position is that for any sentencing enhancements, they just have to put in the caption, we may seek a sentencing enhancement, and then not have any other notice or elements in the body of the charging document or pleading itself.
So if there was a timely objection, and so this is not a waiver issue, that's it was preserved, and on appeal the defendant is now raising that he was prejudiced, this is then a harmless error analysis. If there was error, how was the defendant prejudiced in failing to receive the notice in the body of the indictment under the strangulation count?
Your Honor, I also, and I'll just be candid with the court, I did not find any case law about the standard of review. The jurisdictions that have addressed this have conducted a de novo review in deciding whether the defendant received fair notice of the charges against him or her. So I would not concede that harmless error is the appropriate analysis here. But if it were, this is definitely.
Well, it's not plain error because it was preserved.
That's correct, Your Honor. I would say this is not a plain error case because there was a timely objection and it was preserved to be addressed. And that's where I know that the court in Felder had made some remarks about there being actual notice based on the jury instructions that were provided and their lack of objection and plain error.
Well, I mean, we have the magistrate's complaint, the prior indictment, government argues that, you know, he had all the notice that in terms of the prior documents that this special allegation was an issue in the indictment.
Yes, Your Honor, but I would submit that Mr. Flores had actual notice that the government was not going to seek the sentencing enhancement, and that's you relied on the removal of that notice from the superseding indictment itself. So I can understand it. I kind of understand what I mean. You're kind of left to deal with the fact that you're given, and we can see that it was included in the magistrate's complaint and it was included in the indictment. But I would argue that actually makes it a stronger case for the defendant's reliance on the government's exercise of discretion not to pursue that sentencing enhancement. If we were in the world of plain error, which I would say we're not, I mean, it's clear that there has to be some notice given to a defendant before the court imposes between 5 to 25 years of an additional sentence to run consecutive to the underlying felonies.
Mr. Camacho, the notice requirement is more than just saying felony release. Doesn't it have to have the case reference to which felony?
Yes, Your Honor.
Is the underlying the other felonies?
Yes, Your Honor. And this is 99.9% of the time the government gets it right, and we don't have this problem. And that's why I think the bar is not very high here. There just has to be some notice that's provided. The government in its notice should lay out the felony release of the case that's being alleged that the defendant was allegedly on release for. And they even go as far. I mean, if you just look at the notice that was in the kidnapping, I would concede that would have been sufficient if they had provided similar notice with respect to the strangulation charge. The issue they have is they didn't. And going, I think, to the court's question, would the caption be sufficient? And absolutely not. I mean, there's no reference to what felony release, what case they were on release for, case number. Because then you're like, okay, well, what if this defendant had 3 open felony cases? I mean, you have to provide them some certainty as to what exactly, and then they can make a decision as to whether or not they want to proceed to trial. So I don't think that this is a complex case. It's just, can the government just rely on a caption? And I think I would argue what is more problematic is that the court has recognized there is great latitude to fix that. There was great latitude to fix this issue, and they elected not to do it, to not get a superseding indictment, to not provide notice. And I think we would be in a very different situation if prior to jury deliberations, the government sought and obtained an amendment, or based on this court's holding in Murtaugh, just issued a notice. I mean, it could have been as simple as notice of intent to seek sentencing enhancement for strangulation based on felony release. And I think we would be in a much tougher position on appeal if they had done that. But it was
even without specification of the case or any underlying facts.
No, Your Honor, I think that they would be required to put some of that information, but I don't think that they would have been required to amend the indictment based on this court's holding in Murtaugh. I know that the custom has been to present all that to the grand jury, but I believe what this court's holding in Murtaugh is that for a sentencing enhancement, they can file a notice of intent to seek sentencing enhancement at the front end of a case and not have to worry about presenting that to the grand jury. And that would provide a defendant with adequate notice. But they didn't provide anything.
And the remedy you're seeking is that that we remand for resentencing without the strangulation, the enhancement.
That's correct, Your Honor. We're not challenging the sentence with respect to the underlying felony and the underlying misdemeanor. We're just saying that the 5-year sentence the imposition of that 5-year sentence was in violation of Mr. Flores' due process rights.
We have no further questions, Mr. Camacho.
Thank you, Your Honor.
You'll have 11 minutes. I don't think you'll use them on rebuttal. Mr. Tennyson?
Chief Justice, may it please the court. So a couple items to cover. First, I'm just going to talk about the standard of review. And my understanding is it is de novo. It's a discussion about interpretation of law. We're talking about due process issues. And I realized we didn't, neither of us, I think, looked at the rules of pleading too closely. I looked this morning and I'm looking at 8 GCA 5510 subsection B provides some assistance on what we're looking for here. This concerns form of indictment or information. The indictment or information shall state for each count the official or customary citation of the statute, rule, regulation, or other provision of law which the defendant is alleged therein to have violated. Error in the citation or its omission shall not be ground for dismissal of the indictment or information or for reversal of a conviction if the error or omission did not mislead the defendant to his prejudice. So similar to other standards of review, we are looking, I believe, for prejudice. And a big point here, and I'd like to erase it just off the bat, is we're not arguing that you just need to put it in the caption and you're okay. There are notice requirements. There is due process requirements. Now, there has been some discussion about, there had been the previous indictment, the previous magistrate's complaint, and that in this process, this one notice was removed from the kidnapping, I'm sorry, no, the strangulation charge. So nothing else was removed. And what I find, what troubles me the most is it's still in the caption. And I have the superseding indictment. We look at the second page. It discusses kidnapping, strangulation, charges 9 and 10. Notice commission of a felony while on felony release. If we go down to those charges in the indictment, sandwiched between kidnapping and strangulation is a notice. Notice commission of a felony while on felony release. And this is appellant's excerpt of records, page 21. In the commission of the above offense, Ray David Flores Jr. committed the above felony offense while he was on release pursuant to Chapter 40, Title 8 Guam Code on a pending felony charge, 2 burglary. Then there's a special allegation for use of deadly weapon, conspiracy to commit burglary, theft of property, 3rd-degree felony, filed under Superior Court Criminal Case Number CF 0237-20. So upon seeing this caption and seeing this notice, we go down further in the indictment, and there is a notice. It is in there. It says felony on felony release. Now,
Mr. Tennyson,
yes,
the fact that it was removed from the prior indictment, wouldn't that lead the defendant to believe the government wasn't going to pursue it?
I would agree with that if it was also removed from the caption, but I think the fact that it was still with the caption raises a reasonable inquiry as to, was it unintentionally removed from the body, or did you forget to remove it from the caption?
But when this was brought to the government's attention at the trial stage,
Mhm.
couldn't the government have easily fixed it?
Yes.
I mean, they could have asked the court if they could amend it or gone back for a superseding.
Yes, they could have done that, Your Honor. And of course, in ideal world, that's always what we do, is we find these issues and we immediately take procedural steps to cure them. That wasn't done at the time, as far as I can glean, because the government's belief at that time was you didn't need specificity in linking it, and they were already aware. I think this leads us kind of into a strange chicken and egg problem of, and I've been thinking about service of civil lawsuits, which isn't very helpful here. Because you can challenge service if you show up and you only challenge service. But there's a lot of—
Mr. Tennyson,
Yes.
if I understand your argument, you seem to be conceding that there was a mistake here, that there was a mistake that the body of the indictment did not include the special allegation as noticed in the caption. And that, but it should be the defendant that bears the consequence of that and not the government.
No, so to that, Your Honor, I say, and as far as there was, and I would characterize this as a clerical error because it was deleted. The notice for felony on felony release is the same felony on felony release enhancement for kidnapping and for strangulation.
Yeah, but I think Mr. Camacho's argument goes a little further than just that it wasn't in the indictment, is that there seemed to be a suggestion since it was taken out, it was included in the magistrate's complaint, the special allegation, the indictment, it was not included in the superseding indictment. And so in preparing for a trial, of course, defense counsel wants to beat all the charges and hopefully get acquitted. But in deciding whether to go to trial or not, if the analysis is that the kidnapping charge, proof of those charges as against Mr. Flores is weak, and if the defense counsel says we go to trial, we try and beat the kidnapping charge, and of course we want to be acquitted in all charges, but if you're left with the strangulation charge, you're facing up to 3 years, as opposed to whether or not we try and negotiate a plea, because you are facing all the additional years tied into the kidnapping charge that the special allegation is tied into. So it seemed to me that it would factor in the analysis whether to go to trial or not, to enter into a plea or not, that critical information is not included in the strangulation count. And so I think Mr. Camacho is saying that's the prejudice, in that how he prepared or how they analyzed the case may have been influenced by that information not being included in the indictment.
Yes, Your Honor. And in response to that, the first thought I had when there was some discussion about, well, could this have been cured? There was a discussion during jury instructions, could this have been cured at that point? And the discussion was, yes, the government could have just amended at that point. At that point, there had already been harm in regards to this plea issue. And even insofar as you remedy at that point, defendant can still plea. I think at that point, the defendant was on notice that despite the issue raised of it not being set forth in the body directly beneath the charge, that the government still did intend to pursue it. So at that point, we're looking at, well, how would a procedural amendment give more notice? And I'm not saying we shouldn't have those kinds of procedural requirements. I believe those are very important. Those do help with assisting and effectuating actual notice. But I think there was notice in this case, even despite this clerical issue. And I really do invite this court to look at the superseding indictment where charges 9 and 10 are at, because if we're looking at the construction of the indictment, all of the notices of special issues come directly underneath the charge. When we get down to kidnapping is at the very bottom. We go to the next page. At the top of the page is the notice for felony on felony. Directly beneath that on the same page is the charge for strangulation. So if we're following the form of construction the entire complaint is used, then it falls underneath. But it's actually easier to see the notice of felony on felony release with the strangulation charge.
Yeah, but I don't think that's the point that,
No, it's not, Your Honor, but, and what really.
But where does and when you look at charge 10 in the superseding indictment, what does it indicate that the commission of a felony while on felony release is going to apply to that offense?
It does not. No, it would be under. So normally, if we were following these rules of construction, there would be an identical notice
Underneath
above
10.
Charge 10, but it would be under 10.
Yeah, as the indictment did. If you look at the
Yes.
indictment, the indictment's very clear. In the indictment, it's in charge 4. So charge 3 has the kidnapping, and then the notice commission of felony while on felony release. And then charge 4 has the strangulation and commission of felony and felony release with all the details. But then in the I don't even see it in the caption in this, under charge 10.
You know, in the original indictment, Your Honor?
No, in the superseding indictment. I mean, we talk about it's in the caption,
Mhm.
but I don't even see it in the caption under charge 10.
Superseding indictment I have.
Yeah, on page 12, at least the one,
I'm looking at page 11, Your Honor.
yeah. This is excerpts of record, appellant's excerpts of record 21 of 25 of 55,
Mhm.
dated August 17, 2023.
Yes, Your Honor.
I don't see it on my version.
Yes, I do see it in my it's on, I'm looking at excerpts of record, page 11. We're talking about the caption for charge 10, strangulation. It says as a third-degree felony.
Yeah, I'm looking at the appellant's excerpts,
Okay.
page 21 of 55
I don't know if I have page 21 of 55, Your Honor. Let me.
of the.
Oh, okay,
appellant's
I understand, yes. No, it's not underneath there, Your Honor. It is
Yeah.
above, but it's not beneath.
It's not underneath that
No.
supersedes. So is there another superseding indictment where it's in the caption? No.
No, Your Honor. I think there had been some differences in the prior indictment, but I don't.
Yeah,
have
the
them.
indictment clearly has it
Mhm.
under both count
Under it,
4 and
yes, it
count
does.
5. But
And-
here under charge 10, I don't even see it in a caption. You see it? Yeah.
Yeah, it's in the caption.
Well, I don't see it in excerpts of record 21. I mean,
So it is missing from the body. It's present on in the caption on the second page of the indictment.
oh, just on the not
Yeah.
underneath. I thought it was the caption of the charge. under
Oh,
the
no,
charge
Your Honor,
without
no.
the details. Yeah, I see what you mean. It's on page 2.
Yes, Your Honor.
Okay,
And-
got it. I understand now. I was referring to page 22, the last part of the indictment. It's nowhere in there under a caption.
Correct, Your Honor. Yes, no, it's not.
Yeah,
Um,
okay, got it.
It really just what sticks to me about this case is I would expect counsel, I mean, it's very strong to go in and say caption doesn't matter. We don't need to worry about it. I mean, and I think of this in terms of just a client coming in, they've been named in a caption in a lawsuit. But let's say for some reason, there's no listing of them in the body, a separate enumerated paragraph as to defendant so-and-so is named for tortious, whatever. The person who gets that, sees the caption, their first thought isn't going to be, oh, I don't have any notice of why I'm in here. Just going to see their name and say, do I need to be worried about this? They go talk to the attorney looks at it and says, you know, they're not going to say, yeah, don't worry about it. You're only in the caption. It doesn't matter. They're going to say, this is not clear. We need to go talk to the other side and figure out what's here. This might be an error. Maybe you weren't supposed to be in the caption, or maybe they just left out the information. Now, I suppose a third option is you say, well, let's just keep quiet. Let's not say anything. We'll use this as a procedural defect down the road and try to get it kicked. That's an option too.
Well, I just, the difficulty I'm having
Mhm.
is that you describe it as a clerical error. I mean, there was sloppy work,
And it's speculative on my part,
of-
yes.
on the part of the government in not having a charging document that has all the requirements of what the defendant is being charged with and will be held in terms of standing for trial. And that ambiguity, which has caused problems, your argument is the consequence is that the defendant should then be responsible and bear the consequences and not the government. And I'm just having a little difficulty with that in reference to the defendant having rights under the due process clause to proper notice of what charge he is being charged with and what he is going to be held accountable for in going to trial.
Yes.
And that's no light, small matter.
No, it's not, Your Honor. And I'm of a similar belief that defendant shouldn't be given short thrift. My concern with this case, and it's not, I mean, here's the thing, even, I cite the two cases, Riva and Anderson. Riva sees an issue kind of like this and says, no, this is real close. So I'm not advocating for, oh, this is an easy slam dunk. No, this is, I'm arguing right up on the line on this. And that's Riva. Anderson comes in and says, nah, we don't prefer this. We're not overruling you, but this is a dangerous precedent to get into.
And then you have the later case, Vaquera, which he cites in his brief about a violation of due process to not set forth the sufficient notice.
Yes, Your Honor. And all I can really put my hat on, because this is something if I was on the other side, I would not give short thrift to, is it does still appear in the caption, and clerical issues, sloppiness, other things do occur. And that's as easy as picking up a phone and making a phone call and saying, do you guys plan on going after this enhanced sentence? Because it's in the caption, it's not in the body, following these standard rules of interpretation that you're using here. I just need to be clear for the sake of my client. There was no surprise that seems to be indicated from the record. It was a prepared argument. It was a procedural argument. And I think the defendant took very good advantage of the opportunity provided by the government's, disinclination to just file a second superseding indictment and fix the issue. And this leads us back into issues of notice. If it had been also deleted from the caption and then we said, oh, no, wait, no, we still want it. No. On what basis? Because there is no reasonable question. There's no question of uncertainty about it that would be clarified, but it was brought up, it was discussed, and the defendant was aware that the government intended to pursue it. And that was jury instructions. And this was an issue that.
Yeah, but that was post verdict already. It wasn't.
Well, and they were discussing, in the broadest sense, they were discussing the need for bifurcation before the trial even started, because there was felony on felony for the kidnapping. And then that was kicked out by judgment of acquittal. And then all of a sudden, well, how could we prepare for this felony on felony charge that, while it's in the caption and captions don't mean anything, therefore we can ignore that. It's not in the body and you lose. It's just the flippancy of that argument that gives me pause, Your Honor.
Well, I think as Justice Merriman has pointed out, there needs to be more than just that there is an special allegation in the caption. There aren't the facts as to what is it that is being alleged in terms of felony on felony release. Now, I understand that, that is not a difficult thing to prove. But I think the whole issue here is notice before trial.
Yes.
And when we think about the reasonableness of the defendant's reliance, you have this whole big lengthy paragraph that's obviously been intentionally removed, or maybe unintentionally, but clearly removed from the body of it, and which it seems more plausible that the expectation would be they're not going to pursue that, rather than, oh, I forgot to just delete it from the top of the caption. And so at least it's a very plausible belief that that was the expectation, that they were not going to pursue that felony and felony release for the strangulation charge.
And that I can't dispute that as a reasonable interpretation of the facts, Your Honor. As counsel, if I was on that other side, my hesitancies here is still, I'm not going to take that for granted. Now, and opposing counsel, defense counsel didn't take it for granted. They did raise it. They did challenge it, and which cuts against the other policy argument I have, which I think is not so applicable here, but I will just briefly go over it. And this cuts against, I think, my side more so, but there is a desire for, when procedural issues do come up of this nature, that they get raised as soon as practicable so they can be resolved. The danger is if we don't, resolve them in that way, then they just become methods for appellate, error reversal, go up and argue it on a procedural technicality. The issue we have here is it was raised in trial court and government could have amended, didn't. But made clear that they intended on pursuing it. So I think what it comes down to is where was the error / harm / notice of the government's intention to proceed? Was that at a time that the government could have fixed it, which I think the discussion has been they could have just done a superseding and they didn't, even though they told the defendant they intended to proceed. It's I don't know which side of the line the case is on. I'm clearly on the side I'm arguing for. The position just really is there was a sufficient basis to question it, to be aware of it. It is in there with specificity. They are both felonies, and the defendant did become aware of it during proceedings.
Well, I think I'm following your argument in terms of timeliness, raising an objection to an issue with the indictment, the shortcoming in the indictment. And if you quoted 55, I think 10, that, and it, or was it 65, where it has to be raised prior to trial, unless it has to do with jurisdiction or it doesn't charge an offense. And so, and that's where if there was an error and it was preserved, then it becomes, I still think, a harmless error analysis. How is the defendant prejudiced? And the argument is that had the notice been provided prior to trial, it would have factored into whether or not to proceed with trial and what are the trial strategies as opposed to trying to negotiate the most favorable plea. So there is it is an important factor in reference to the notice and whether it was properly raised prior to trial. And the analysis, I think, is that, was the defendant prejudiced at the end of the day? And Mr. Camacho is, suggesting that he wasn't given any proper notice, which he didn't, which factored into how the defense may have prepared for trial.
And that is a possibility, Your Honor. What I'm uncertain of in regards to the prejudice argument, because I think it is it ties into the ability to know what's going on with potential sentencing to plea, to do other things and take all that into consideration, less so than an inability to defend.
I don't think he's raising it as an inability to provide a defense to the special enhancement or to double jeopardy issue. I don't think that's his argument. It's understanding the maximum penalty that he could have been facing.
And for that, Your Honor, what I'm not certain, and the record doesn't say, and we just have to live with it. We don't know the discussions with defense counsel. I mean, I look at it, if it wasn't also in the caption, I mean, my sticking point is just, I would reach out and say, hey, I need to talk to my client so they know what's going on with this commission of felony on felony release that's in the caption, but not in the body, like what happened. I want to know that before I advise my client, because I would be uncomfortable with this in the caption just because it's in the caption. Why is it there? I would want to know. And that does serve as a form of notice. It flags an issue that needs to be delved into. And we don't know, the record doesn't say. There could have been a discussion with the defendant, the government might try to go after it. If they do, we'll raise a procedural argument. This is how we'll deal with it. And that's what happened. But beyond that, it could also be they took it for granted that, it was removed, they're not going to pursue it.
Well, I think this case is an illustration of why, as you're, I think, trying to explain that there should be an objection lodged if there is a pretrial, if there is a problem with the indictment. Otherwise, as can be seen, defense counsel can remain quiet, take advantage. If he's convicted, then raise it post-trial. But you know, that, I mean, the defendant is entitled to roll that dice. And while we understand the policy in reference to raising it at the earliest opportunity, the defendant, if there was error in the timeliness of not raising it, it then becomes, again, in my mind, whether or not the error was harmless.
Mhm.
And the argument is, no, it was not, because it affected how he may have prepared or handled the strategies in reference to going to trial.
In this case, Your Honor, I would say, yes, it did impact the strategies. I just don't have enough information to definitively say one way or the other, which that is. And unfortunately, well, it's not my job, Your Honor, that I would leave that to the court's determination to balance the equities and determine where that dice should fall. But as I indicated early on, I think this is a close issue as to the line, which side it's on. I leave that to the court. All we can do is provide some guidance and alternate perspective to try to reach an informed decision. And if there's no further questions, I'd rest at this time. Thank you.
All right, thank you, Mr. Tennyson. Mr. Camacho?
Yes, Your Honor. I think, well, I mean, it's clear there was prejudice that my client suffered in terms of the full range of penalties that he would be facing if he elected to proceed to trial. Really what this case is whether the government should be held to its pleadings. And the answer is yes. If the government says removes a notice from the body of a pleading, I mean, and I guess I disagree. I don't think it's defense counsel's obligation at that point to say, hey, did you guys forget to include the sentencing enhancement that would increase my client's exposure? Defense counsel, I wasn't privy to it, but I'm sure they had mentioned that this was going on and how it changed over time. But once there was an election to proceed to trial on that superseding and to proceed to jury deliberation and to proceed to verdict on that superseding indictment, the government was bound to deal with the consequence of its omission. And I don't believe this is a case of a pleading or of a form type of objection. Due process, this really goes towards the notice that is provided to a defendant in evaluating and making these important decisions as to whether to proceed to trial or not. This is not, we put C3 instead of C4, or we didn't specify which subsection of a statute. They removed the intent to seek a sentencing enhancement. It's not a matter of whether or not the statute was right. They elected to take that out, and Mr. Flores properly relied on it. I don't believe defense counsel was under any obligation during the discussion of how the superseding indictment would be presented to the jury for deliberations was required to raise it, but she did. And again, I invite the court to look at it. And the response from the government was, it wouldn't be hard for us to get a second amended superseding indictment. They just chose not to do it. So what we're asking for the court to do is to just clearly state that the government has to do more than a caption if it intends on seeking a sentencing enhancement to vacate the 5-year sentence and just to remand, and my client would serve the remaining 4 years that he was sentenced to.
All right.
Thank you.
All right, thank you, Mr. Camacho. Thank you, Mr. Tennyson. The court will take the matter under advisement and will issue a written opinion.